Please be seated. Court now calls case number CV130260, Hammerman versus Northern Trust. Good morning, counsel. Let me advise you these proceedings are being audio and video recorded, and that within a couple of days of today's oral argument, the video and audio will be available on the court's website, so I want you to understand that. When you begin your argument, please identify yourself and your client. You have 20 minutes for your argument. Counsel for appellant, if you want to set aside some time for rebuttal, let us know. We have read your briefs. We've discussed the case in conference, so we're very familiar with the issues. Counsel?
Thank you, Your Honor. May it please the court, I'm Al Arpad with Fenimore Craig, and with me is my partner, Roger Hargrove. We are here for the former trustee, the respondent, and the appellant on appeal, Northern Trust. I would like to reserve a couple of minutes at the end for rebuttal. It's also very important to answer your questions, so I'm not particular about how much, but I'd like to have a little bit of time to get back up here just to clarify things if it needs to be done.
In terms of priority of answering questions, I would ask that you prioritize my questions first.
Thank you, Your
Judge
Honor.
Thompson second, and Judge Swan's last, lowest priority.
Thank you, Your Honor. I appreciate that clarification.
So let me ask you a question.
Yes, Your Honor.
Is it correct to say that the trial judge focused on the apparent fact that the attorney's advice in this case was paid for by trust funds?
I believe the trial court focused on that really pretty much to the exclusion of anything else. If you look at the transcript, I think that's clear. The order's very vague in those terms, but if you look at the transcript, I think that's quite clear.
The thought process being that if the trust paid for it, the trust basically owned the information.
I think that was the extent of the reasoning, Your Honor. One thing I'll start out with that I think the parties actually do agree on, and that is that we could really use guidance on this. Trustees in Arizona could really use published guidance on what the standard is, because whatever it is, my client will be much better off to know what it is, and they can structure their conduct accordingly.
There is some guidance in the restatement, correct?
Well, there's different guidance from different places, Your Honor. And there really is an issue in Arizona whether the restatement second or the restatement third is the one you should look at, and it isn't the law. Even if it is the law, the extent of exceptions to the privilege are a little bit of a delicate issue, and you've got multiple facts to consider in this case. The background, the basic rule of privilege, is that you have an attorney plus a client plus a communication, and generally that means you have privilege, assuming that it was a reasonably confidential communication, assuming there's no waiver, assuming you can identify the client. That's where the complications come in.
As long as Judge Gould's not going to ask you a question, let me, with regard to the information that has not yet been produced, is it fair to say that it breaks down? I obviously haven't seen it, and nobody's conducted an in-camera review. But is it fair to say that that it breaks down into two categories, or are there more? Two categories meaning the trustee receiving legal advice in its capacity as trustee and in its corporate capacity looking out for its own interests, if you will.
The capacity issue is a little bit of a complicated one, so I'll try to start somewhere else. It is definitely true that Northern Trust produced a bunch of information that was administrative in nature, and that's essentially going on some combination of the restatement and the California cases and the various other guidance that's out there. That's information that we thought was in the best interest of the trust and the beneficiaries, needed to be turned over so that they could understand what was going on. And given the guidance that existed from outside Arizona, I think it was a reasonable place to draw the line. There is also a category where Northern Trust's employees were consulting with their lawyers about issues that potentially would involve their liability. And since they only had one set of lawyers at this time, those are the lawyers that they were talking to. And I would suggest to you that that's going to be the case for almost any trustee initially before the dispute turns into litigation. So there is a second category of whether it really means it's in their corporate capacity or their trustee capacity. I would suggest to you that the better place to draw the line is the subject matter of the communication. It's in their corporate capacity in the sense that It's about issues that could potentially result in them having to pay damages out of their pocket.
Okay. And that's the only category that we're arguing about today?
Yes, Your Honor.
Okay. Now, you mentioned they only had one set of lawyers. There's nothing in the record that places the question squarely before us today, but obviously the mere statement of that fact raises in my mind the question of conflict of interest. Is that lurking in the background of this analysis?
I would suggest to you that conflict of interest lurks in the background of every single trust case you will ever see, because it is inherent in the relationship of a trustee and a beneficiary that the trustee agrees to put the beneficiary's interest before the trustee's interest.
I didn't mean conflict of interest faced by the trustee, but conflict of interest faced by counsel.
That is also potentially true, and also happens in almost, unless you want to promulgate the rule that a trustee should immediately hire two sets of counsel upon taking over a trust, so that they have one counsel to go to on administrative questions and a different counsel to go to on liability questions. And then, of course, you have to get to who pays for those, and it's probably going to be the trust one way or the other, because they're either going to pay for it directly or through increased trustee fees. Unless you want to create a rule that says that's what trustees should be doing, you are always going to have a trustee doing their best to navigate conflicts, disputes, and other problems, because those are absolutely routine. And then you're going to have the trustee's counsel also doing their best to advise the trustee what to do about those various conflicts and disputes and problems coming up. The very first thing that the client might come into the trustee and do and say, Mr. Lawyer, what should I be doing about this problem? And maybe the lawyer's response is, ooh, I think you need separate counsel. That in itself ought to be a privileged conversation. Nobody who goes to a lawyer wants that to be the thing that's being waved in front of the jury. Ooh, I think you might need separate counsel. Very early in the process, those kinds of conversations, as a matter of course, are going to occur between every trustee and their regular single counsel that they're using to just try and navigate these waters and do a good job as trustee. I think it's inherent. Does that answer your question, though?
Well, it does in part. I mean, you said if we want to promulgate a rule, I don't think the question is our desire so much as maybe our interpretation of ER 1.7. Do you believe that such a clearly stated rule might be appropriate given the issues raised by this case?
I think it will. If the question is, do I think a rule that you should always have two counsel is appropriate? No, I don't. If your question is, you haven't asked it yet, but you probably will eventually, what does my client want out of this? We could live with any of the standards here, except we really would be unhappy with the one that says we have to have multiple counsel all the time because nothing is privileged with the regular trust administrative counsel. I don't think that makes sense. I also don't think it makes sense, and particularly for non-institutional trustees. I mean, one thing to clarify, I said we only had one set of counsel. We had one set of outside counsel. There was an inside counsel involved here who's also our counsel. That's one of the little issues that you may get to after you've solved the big issue here. But we could live with a sort of a pure, analytically pure standard that says we have a regular attorney-client privilege like everybody else. I think if you look at the law and the existing law in Arizona that says that we're definitely the lawyer's client, generally speaking, even though the trust commonly pays for that, that would be sort of the natural result. We can also live with the sort of middle ground standard that says there's some kind of a carve-out. For policy reasons, for administrative types of things that the lawyer did, just because the successor trustee is going to have a really hard time picking up the pieces if they don't get something. The question is where to draw that line.
About vis-a-vis the beneficiary?
Vis-a-vis the beneficiary, I think you have to go to a pretty extreme interpretation. I mean, we know in Arizona it's established the beneficiary isn't the trustee lawyer's client. The trustee is the trustee lawyer's client. And so you have to go pretty far down the road to really say that the beneficiary in her own right has a right to look at all of the attorney-client files.
Well, to say all, yeah, you'd have to go pretty far down the road. But what if you were to say that with regard to that category of communications relating to trust administration rather than the trustee's potential liability, the so-called fiduciary exception applies. Would that be an extreme result?
That would not be extreme. It would not be, I mean, in many trust situations, it could be the beneficiary who's the successor trustee. So in that sense, it's not extreme. As a practical matter, the successor trustee is unlikely to hide those communications from the beneficiary unless the beneficiary is the opposing party. It really is going to depend on the situation. I don't think the beneficiary has a per se right to penetrate any attorney-client communications. There may be limited waivers. I don't think trustees should be penalized for doing what Northern Trust did in this case and releasing the administrative type communications, at least when the standards is unclear as it is. And so a trustee might decide that a beneficiary needs to see that, but many times you've got the beneficiaries going in different directions, or the beneficiary is on the other side of the litigation even from the successor trustee. So in that case, the successor trustee ought to have the entire privilege over all of that and be able to maintain it. Does that answer your question?
It does, thank you.
But there is a statutory duty of a trustee to keep beneficiaries informed of matters pertinent to trust administration, correct?
That's absolutely true, and Northern Trust and any other trustee has an absolute duty. And in fact, the Uniform Trust Code really defines it much more clearly than it was defined in the past, what it is you have to report. And it's substantial. You have to report the actual facts of what's going on with the trust. But I don't think that relates at all to the communications between the trustee and the trustee's counsel. And I think that's what's been found in the modern cases pretty consistently. So the trial court essentially, as you alluded to, Judge Thompson, applied a simple who paid standard. I think that's pretty clearly not the right standard. Not only is it not right, it really, in a sense, is a red herring for purposes of analysis. That's supposed to be a factor in deciding who the lawyer's client is. We know who the lawyer's client is in this case. It's the trustee. That part of it's already been decided. Who paid shouldn't even really be on the radar. The only way who paid comes into these types of cases is if the trustee gets far enough off track, eventually the trial judge brings them to heel, possibly removes them, possibly surcharges them, does something like that. So if there's been a real injustice in terms of the beneficiaries paying for the trustee's lawyer, that can get corrected, but it's corrected in accounting proceedings, not by saying, you know what, retroactively, that lawyer was never your lawyer and you have to turn everything over to the other side in this litigation. That's not the way to approach that the payment problem. I also do want to make sure I emphasize at some point today that under Arizona law, it's absolutely routine, not just for there to be all kinds of conflicts and disputes and things going on in trusts, but that it's absolutely routine for trustees' counsel to be paid out of the trust. And again, eventually the trial court gets to look at that and decide whether it was done properly, but that's what you should expect in most cases like this coming before you, is that the trustee may be getting paid directly if it's particularly an institutional trustee, and the trustee's lawyer is getting paid from the trust. So that's almost always going to be true. So there are two sets of questions that you really have to deal with. The one is, I think, what we've been talking about so far. You have to figure out what is the standard in Arizona and what should trustees do in the future. Should they rush to obtain second counsel that they're paying for out of their own pockets, or can they in fact do what they did here? Or should there possibly even be a broader attorney-client privilege as would apply to an ordinary person? That's the big question. The little questions, as I mentioned a little bit earlier, are the in-house counsel issue. I don't think that's really been dealt with in Arizona, but on many of these communications, not all, we would have to resort the list if that became the standard, but on many of these communications, our in-house counsel, Steve Youngling, was acting as a lawyer on those communications, and that should count for attorney-client privilege, because who he was talking to was the other lawyer who's an agent for the trust and the trustee employees. That's the sort of thing under Arizona's attorney-client privilege that ought to be privileged. The need, as you've mentioned, for in-camera review. If the court adopts any type of exception or carve-out to the trustee's attorney-client privilege, then unless we can come to some type of stipulation, there probably does need to be an in-camera review here. The only reason the trial court could avoid doing that is because the trial court adopted an absolute standard under which the content of the communications didn't matter. The in-camera review will be, I think, of the content of the communications, whether they're the sort of thing that someone ought to reasonably expect their lawyer to keep in confidence, rather than something highly abstract such as capacity. I think subject matter makes a lot more sense in terms of how the in-camera review is conducted.
Can you explain that distinction a little differently? I mean, I assume that with regard to any communication with a lawyer, the general expectation is that it would be kept confidential. To the extent that there is a carve-out, perhaps a large carve-out, for matters relating to trust administration and disclosure to certain persons, like beneficiaries or successor trustees, the subject matter of that would still be the subject matter of privilege, generally speaking, right?
I think that's true. And so
even though the universe of people with respect to whom that privilege might not apply is small but existent. When we get to this case, though, isn't capacity sort of the touchstone for the distinction between what this limited universe of people can see and what they can't?
In a sense. I don't want to focus too closely on capacity because it's not like we were consulting Quarles and Brady about completely unrelated stuff about how to run Northern Trust. It was about this case, but it was specifically about things like disputes, things like liability, things like conflicts, things that would be problematic if your lawyer went and told them to the other side in a lawsuit.
So in other words, it's the interest at stake that really is the dividing line in your mind.
I believe so. And that's capacity in the sense that it means that Northern Trust, that it particularly applies to Northern Trust seeking advice about its own potential liability and its own conduct, as opposed to seeking advice about the rent on the building, something like that. That's where I think the line should be drawn. You use the word related. I would be very careful about saying things related to administrative matters, because I think all of these communications are going to be to some extent related to the actual facts in front of the trustee. It's not just that they are going to be completely unrelated. It's that the trustee says, well, wait a minute, I have a conflict of interest. That should be privileged. And the lawyer's the expert. The lawyer is the one who would know whether you have a conflict of interest. So in an average person who's acting as a trustee's experience, they're going to go into the lawyer, they're going to say what the problem is, and then they're going to find out they have the conflict of interest. That's the type of conversation that really ought to be privileged. I'll reserve the rest of my time unless you have other questions.
All right, thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Mark House of law firm Becker & House. I represent Janie Hammerman, DBK Residuary Property LLC, and Bank of Arizona, the collective appellees in this matter. The one piece I will agree with Mr. Arpad on wholeheartedly is that trustees in Arizona need explicit guidance on these issues relating to privilege in terms of how the privilege works with successor trustees and vis-a-vis the beneficiaries. Beyond that, our argument functionally breaks down into three component pieces. One is the issue with the Bank of Arizona taking over as successor trustee and what ability they have to assert and or waive the privilege that Northern Trust held with Quarles and Brady. Number two is the issue with DBK LLC as essentially Northern Trust served as the manager of DBK. Bank of Arizona now serves as the manager of DBK, and so anything that would have been privileged inside of the DBK litigation, we believe that Bank of Arizona has the ability to waive that privilege as well. Slightly different issues, although I think they're very, very similar. And then the final issue is whether there should exist any privilege at all vis-a-vis the beneficiaries of the trust, primarily Janie Hammerman. And so I guess, starting with our successor trustee issue, the best guidance that we have on the successor trustee issue comes out of the Mueller case out of California. And in that situation, the court made it very clear that successor trustees, in order to effectively administer the trust going forward, need access to all of the information that the predecessor trustee had. And that's consistent with trust administration generally. A successor trustee needs the ability to fully understand everything that has gone on prior to their tenure as in terms of taking over the trust.
With regard to trust administration, sure. But with regard to potential issues surrounding the personal liability of the predecessor trustee?
Your Honor, I would assert that, yeah, even with regard to potential issues of personal liability.
Why?
Well, to the extent that it impacts the ability to administer the trust, like it did in this case, where one of the issues that was being raised in the underlying litigation, and this has been since resolved, but one of the issues that was raised in the underlying litigation was whether the trustee was, for lack of a better term, in cahoots with the tenant in terms of the build out on the property. And disproving that theory was part of what we had to do as in our incapacities.
You've just established relevance, but that doesn't establish the absence of privilege.
Well, Your Honor, I think in terms of it shows the need for the successor trustee to have access to the information, and this is where.
Well, but again, I'm sorry. Judge Gould's questions take place.
No, they don't. Well, I mean, I guess you could extend that argument, couldn't you? Let's say they had hired a separate attorney. Well, your client needs that information then, too, right?
Well, and Your Honor, maybe this
Why
leads.
can't they go and get it from the separate attorney they hired as well?
If there is a separate attorney involved, and so Northern and what should have happened in this case is Northern is administering this trust, and everything is fine and dandy. That we're negotiating the lease. We've got TW Warehouse coming into play. Everything is fine. And then the whole thing starts to implode, okay? Northern needs to look to somebody else and say, okay, do I, Northern Trust Corporation, have liability for what I did as trustee? That advice needs to come from someone other than Quarles and Brady in this case. And they need to pay for it on their own. It needs to come out of their own nickel. And if they stay in, Judge Swan, I realize I'm not answering your question at the moment.
No, it's okay.
I will get to it.
It's all related. You may be right that advice should come from someone other than Quarles, and you may be right that somebody else other than the trust should pay for it. I don't know in the circumstances of this case if that's true or not, but it's easy to imagine hypotheticals that come out either way. The question is, though, not do you need the information, not should the lawyer have gotten independent counsel, but is there a privilege? And so it seems like you're discussing all of the ancillary issues, but not the central issue of is there a privilege with regard to this information?
Absolutely. The information is privileged. It's just it's a question of who has access to it. Okay. Now, when I talk momentarily about the beneficiary side of things, I'm going to ask you to kind of reframe the analysis a little bit. But when we're talking about the successor trustee, that information absolutely is privileged vis-a-vis the rest of the world. It's just vis-a-vis the successor trustee, they inherit in that capacity as successor trustee the ability to assert or waive the privilege. And, Your Honor, if you take a look at the document itself in this case, I mean, you know, what the Mueller opinion is saying is, you know, we look to the terms of the document and we look to the body of law, and in our powers and duties of trustee, it says any reference to the trustee in this agreement shall include any and all trustees at any time serving, unless the context clearly indicates otherwise. Each successor trustee under this agreement shall have, exercise, and enjoy all the rights, powers, and privileges, both discretionary and ministerial, as are herein and hereby given and granted unto the original trustee. That language gives the explicit authority in the document to come in and say, yes, we can raise the privilege, we can waive the privilege, we can assert the privilege, we can do whatever. This is successor trustees' ability to handle this trust however they think is necessary.
Well, there's no question in my mind that that's correct with regard to what I think is the largest body of information, and that's everything that has to do with administering the trust. But when it comes to the predecessor trustee getting advice as to its own personal liability, it is in a conflict situation, at least ethereally, it is in a conflict situation vis-a-vis the beneficiary and vis-a-vis the successor trustee. So at that point, does the successor trustee's inheritance of all the privilege really apply to the narrow body of communications we're talking about here?
I believe that it does.
And why is that? Because the provision you're citing suggests that the successor trustee receives the full body of the full power, the full body of privilege and everything that it would have acting as trustee. But it doesn't say anything about the predecessor trustee's personal or corporate interests that's unrelated to the administration of the trust.
And Your Honor, if there was advice received that is independent and separate from the administration of the trust that was specifically denoted as such, then you are absolutely correct. The successor trustee would have no ability to go in and get that because it's not, that is the corporate basis for it. That's not the trustee.
Do I hear a settlement in the offing here? Would an in-camera review simply solve this problem?
Please don't give us that ruling. I apologize. Just
not the word settlement, but an in-camera review. I mean, surely you must expect that that's something that would be on the table.
As part of a potential remand, without conceding that would solve the problem, yes, I believe that is, it would be a decent structure going forward for trustees to look. I would just assert that in this case, we need a better, we're going to need a solid rule as to what the law is for our trial judge to go back and do an in-camera review. To just go say, do an in-camera review and then give us a decision is not going to, with no guidance, is pointless.
Understood, but it sounds like both sides here are acknowledging that an in-camera review might be the prudent way to proceed.
Yes, although I take the position that the waiver argument is a little stronger than that. I do believe that, and as Commissioner Kubashevsky pointed out in his mainly in the oral argument, not so much in the order. I'll agree with Mr. Arpad on that, but he did focus a lot about who paid for this, and frankly, that is a relevant consideration. It's
dispositive?
No. Okay. We went from it being, this is unfortunate, and got to love the drafters of the restatement. We went from the restatement second, where it was, for the most part, outcome dispositive. If you paid for the advice, it belongs to you. The restatement third changes it into a factor. So it's still an important factor, but it's not outcome determinative anymore.
Right, and our ethical rules actually would support that view too, because we, in ER 1.5, we accept the idea that somebody may pay for a representation who has absolutely no interest in it other than getting the bill. I mean, insurance companies do it all the time.
That is correct, but that is not, in a trust situation, it's a slightly different. I mean, an insurance company is a different creature than a trust.
Well, take Mom then. Mom pays for the lawyer, and still it doesn't have a right to see the privileged communications.
That is correct. But even then, it's a third-party guarantor of a legal bill. It's a very different structure than it is where we have a trust with a trustee, with various other duties. Mom doesn't owe any duty to the son. Mom doesn't owe any duty to the lawyer. Whereas in this situation, the trustee owes an absolute duty of loyalty to the beneficiaries of a trust, and maybe that's a nice segue into the beneficiary view, kind of the beneficiary side of this. Our position under the beneficiaries' right to information is reasonably clear, and as Judge Thompson pointed out earlier, there's an absolute duty to provide information necessary for the beneficiaries to protect their interests. Okay, that is the way that 10813 is written. It is not, oh, we get to disclose what we think might not hurt us. It's not, oh, we don't have to disclose if there's a potential cause of action. It is an absolute, you will disclose if it's necessary for the beneficiaries to protect their interest. That has to be disclosed. And so there's no exception for anything else that's going on. And the restatement and the comments to Uniform Trust Code have specifically left various pieces of this open. And one of the pieces that they have left open is, whether you have to tell a beneficiary about a breach of some breach of a duty of loyalty, and they've left open this issue on the duty to disclose attorney-client privilege, what would otherwise be attorney-client privilege communications. And earlier in my argument, I expressed that I'm going to ask you to reframe things a little bit, and this is where that comes in. By including beneficiaries in the kind of zone of privilege, so to speak, you are actually increasing the ability for trustees to have free communications with their counsel. Now, not when they screw up, but if beneficiaries are not entitled to documents without some kind of a waiver of the attorney-client privilege, then the theory an argument could certainly be raised that, well, once it's waived for one, it's waived for all. Everybody else now has access to those privileged communications, even beyond the scope of a dispute between a trustee and a beneficiary. For instance, in this case, if we were involved in a series of lawsuits regarding liens, and that's the underlying lawsuit with Northern Trust as well. If the disclosure of information to a beneficiary is considered a waiver of the attorney-client privilege, then one of those claimants could come in and say, the attorney-client privilege has been waived, now you have to give us all of this information. It's not just to the beneficiaries, it would be treated as a general waiver, because now you have a non-party receiving access to information that would otherwise be privileged. That actually hurts the privilege way more than what I'm suggesting that what the appellee is asserting here. What we are asking this court to do is adopt a rule that says the beneficiaries are within the scope of the privilege. It is a mandatory obligation to disclose information to the beneficiaries, which effectively brings them within the scope of an ongoing privileged communication. If it's a mandatory obligation to disclose it, then
you're
clearly
talking about the fiduciary exception.
Yes, a slightly different tack on the fiduciary exception. The fiduciary exception in American law is not well defined. There's a few primary cases that we all bandy about, and whether you believe the Wells Fargo, Huey DeShazo line of cases or the Riggs, kind of the Riggs line of cases on the other side, under any of those cases, it's not a very well defined doctrine. And what I think we can do in order to provide a kind of a better a better structure to the fiduciary exception is to basically incorporate the beneficiaries as part of the privilege. Now they may not have. But
if you did that, let's say we agree with you. If you did that, would there be yet another exception to the exception for advice, the purpose of which is to ensure that the trustee is steering clear of personal liability?
I think then you still fall back on that same issue under Restatement 382, where you're looking at information that does not necessarily have to be disclosed, and that's when you have to receive the independent advice from an independent counsel.
So, but it's possible, is it not, that the trustee would go to the trust's counsel and say, here's what I've got going on. Am I in trouble, or am I going down a route that is going to be dangerous to me? Those conversations happen. There may be a few of them, and prudent trust counsel is going to fairly quickly say, I think you really need to talk to somebody else about this. But until that referral occurs, There may be a small universe of communications that are sought for the purpose of protecting the trustee. Is it your position that even there's no privilege even there?
Yes. And the reason why is because of this absolute duty of disclosure. Okay. A trustee has Your Honor, I also look at this in the terms of like an attorney representing a client. There are very few absolute duties of loyalty that we run into in the law. Okay, and I mean even a personal representative beneficiary relationship is different than a trustee beneficiary relationship. One is a duty of fairness and impartiality. One is an absolute duty of loyalty. The only other area we run into well, I won't say the only other area, but the one that I'm most familiar with is an attorney-client relationship. I couldn't go using my client's money and ask for advice on whether I screwed up, and without disclosing it to the client. You couldn't do that. And for a trustee who owes the same undivided duty of loyalty to say that, oh, I can hide this from my beneficiary that I may have screwed up, and then go have the trust pay for the advice that says either I did or I didn't, and then never have to disclose it, is just an anomaly.
Well, it may. I'm not touching on the idea of who properly pays for the advice. It may be that money has to be refunded to the trust. I don't know, but there is a difference, though, isn't there, between a lawyer who has a relationship with a client and a duty to a client, and a trustee who has a duty to a trust versus a beneficiary to a trust?
Okay. Trustees owe duties to beneficiaries.
They do owe duties to beneficiaries.
Beneficiaries do not owe duties to trustees.
Fair enough, but there is an entity theory of a trust that creates a slight. It would be sort of like being saying that you as a lawyer owe a duty to a corporation, and that translates into a duty directly to shareholders.
Well, Your Honor, take the Sleeth opinion that you guys gave us a couple of years ago, and one of the concluding remarks in the Sleeth opinion was that attorneys need to be very careful about the duties that they owe. Let me see if I can. It's worth actually repeating precisely. Yeah, maybe worth repeating, but I'm not going to find it. Anyway, the Sleeth opinion basically comes down and says that attorneys need to be very, very careful about their interactions with wards and with trust beneficiaries. And trust beneficiaries is expressly included in that kind of concept of derivative fiduciary duty. And the Sleeth opinion is kind of the last guidance we have on interactions between fiduciaries and their derivative, and derivative duties. And the clear import of the Sleeth decision was be very careful. You owe a lot of duties to a lot of people. Be very careful how you proceed. And this is the argument that appellees are making today is consistent with that entire Sleeth line of cases. I see my time has expired. Thank you.
Thank you, counsel.
Yes, Your Honor. Just a couple of quick points. The DBK issue, I would submit to you, you really can't and shouldn't decide on this record. It's extremely underdeveloped. It's a disregarded single-member entity. There are no facts in the record that would tell you that that entity had interests of its own, should have had separate counsel, could have had separate counsel, or that it was anybody's intent that the lawyers were working for the DBK entity as opposed to the trust. I think everything you'll read below, they go together, the trust and DBK. So the trial court should decide that in the first instance if we're going to look at that at all. The second point is that there is a distinction between the duty to notify beneficiaries of a potential breach of trust and the duties to turn over your lawyer's files containing attorney-client communications. And I don't think this case presents the issue of how far you have to go with the duty to notify somebody of a breach. I think I would agree with Mr. House that you have some duty to notify. I don't know exactly where you draw that line, but I don't think you draw it at, okay, here are my files, you decide what the breach is. Here are my lawyer's attorney-client files, you decide what the breach is. on a technical point, the paragraph of the trust document that counsel is referencing about the privilege passing down, I don't think that privilege probably means attorney-client privilege, but even if you assume that it does, what it actually says is I am passing the original trustor, who is the original trustee, who is the grantor. I'm passing my privilege down to successor trustees. It doesn't say every successor trustee is also waiving their privilege and passing it down. So if you do that kind of fine analysis of whose privilege it is, that paragraph actually doesn't even necessarily apply to Northern Trust. And there are technical reasons I won't burden you with, but it would be a somewhat reasonable thing for a decedent to do, to say when I die, here's who's going to hold my privilege. It's going to be the successor trustee who's controlling all my assets. That might make sense. Doesn't, as a matter of law, mean that they're waiving it as to future trustees, and I don't think they even can. Fourth point, just real quickly, I think you're exactly right that unless you adopt a very extreme standard, either that there's a complete blanket privilege that can't really be penetrated, or that the privilege is totally dependent on who paid, which the trial court did. Anything in between there does have to go back for an in-camera review, because somebody has to decide, did we classify those things right or not? And that really is where these things probably should be decided, by a trial judge who looks at them and says, is this something that merits the privilege or isn't it?
Now, you would agree, I take it, that if we were to acknowledge that there might be appropriately privileged exploratory communications in which the trustee is seeking advice about its own potential liability, those ought to be pretty few. Because if there's anything really to discuss beyond just a reality check, independent counsel is going to need to come in pretty quick.
I don't think I do agree with that, because my experience is working with both beneficiaries and fiduciaries is that those things come up all the time. And if
well, they may come up all the time. Okay, few might have been a bad word. There may be many of them, but they shouldn't go too deep.
Again, it depends on the nature. Yes, at some point, somebody has to make a decision about retaining separate counsel. And as I think I've mentioned already, very likely it's that first lawyer who takes the first cut at saying that.
If that first lawyer sees anything of substance in the question, pretty quickly, independent counsel would be required.
It is a constant problem for trust counsel, is we are under a great deal of pressure to not run up the fees by having a lawyer for everybody on both sides of the room, because that way the decedent's estate or trust ends up gone very quickly. So it is a balancing act for the lawyer there. So I don't want to say no. I think that counsel frequently try valiantly to figure out a way to resolve this without the conflict growing to the point where you need independent counsel.
Okay. If you got a banker's box of emails, though, about a particular problem that the trustee is facing in its personal capacity, something tells me that that's too much.
That is likely, and the trial judge is the person in a position to figure that out.
Okay. Thanks.
All right, thank you, counsel. We'll take this matter under advisement and issue a decision. Court's in recess.
Thank you, Your Honor.